Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. And today, what I'm going to talk about is how to request an expedited hearing when you are seeking either child support or alimony pendente lite. So, what that means is you're seeking child support or alimony while a proceeding is ongoing, whether that's a divorce proceeding or a child custody proceeding if you are not married to the opposing party. So, allow me to share my screen. I will show you the relevant statute. So 46B-83 is the statute that has to do with requesting alimony or support, amongst other things, while a proceeding is ongoing. And a little bit, on the fourth line of that statute, it says that upon the filing of a motion requesting an initial order of alimony or support pendente lite that is accompanied by an affidavit on a form prescribed by the chief court administrator by the moving party attesting that, one, the moving party has insufficient funds to meet the moving party's reasonable needs or the reasonable needs of the minor children of the parties. Two, the other party is not providing sufficient funds to the moving party to meet such reasonable needs. And three, the moving party reasonably believes that the other party has sufficient means or earning capacity to so provide, then such hearing shall be held by the court not later than 60 days after the date on which such motion requesting an initial order of alimony or support pendente lite and accompanying affidavit were filed. So you have to file an affidavit along with an underlying motion for alimony or child support, and we've got separate videos on how to file those motions. So I will show you the actual form. I'm not going to include, we often have forms for download on our website. I'm not going to include this form on our website because the judicial department will periodically update the forms. So I don't want that form to fall out of date. So in order to find the form, just do a Google search for JD-FM-303 and you will find this form. So it basically, includes much of what was in the statute. So you just put the judicial district of your case, the court where your case is pending, the name of your case and the docket number, and then you just put your name in this blank and you fill out these lines. Again, you have to say that you have insufficient funds to meet your reasonable needs or the reasonable needs of the children of the parties. So if you're sitting on a bank account with $50,000 in it, or you have sufficient money, you probably should not file this form because you can wait for a normal hearing date. You don't necessarily have to have the hearing within the first 60 days if you have a cushion of money to spend off of. And then it also says the other party is not providing sufficient funds to meet such reasonable needs. So, obviously, if they're paying a significant amount of money, you shouldn't file this form. And you're also saying that, you feel that the other party has the means to provide for the support that you're looking for. So you need to make sure you fulfill all three of those criteria. It's not just one of them. You have to have all three. And then you just sign the form and, have a notary. It has to be notarized, and you submit that with your underlying motion. So those are the basics on how to request that expedited hearing within 60 days. As usual, if you have any questions, feel free to contact our office. And if you are looking for representation in a divorce or other family law case, please don't hesitate to contact our office.